The moment Congresswoman Jasmine Crockett entered Judge Andrew H. Stone's federal courtroom, the atmosphere turned electric. What happened in the next 30 seconds would stun the legal world and produce the most viral courtroom exchange of 2025. Judge Stones, seated high in his bench, dressed in his traditional black robes, looked down at the 33-year-old freshman congresswoman with what could only be described as condescension. His lined face, framed by silver hair and shaped by decades of legal dominance, formed a smirk that would soon become his greatest error. "Congresswoman Crockett," he began, his voice cutting through the packed courtroom, "I hear you've got thoughts on how the judiciary works. How refreshing, a politician schooling the courts." The room fell still. Lawyers, reporters, and spectators held their breath. Crockett stood firm at the plaintiff's table, her burgundy blazer sharp, her natural hair impeccably styled, and her brown eyes burning with intensity. A Firestone's clearly misjudged. What he didn't realize was that Crockett came armed not just with facts, but with strategy. And she was about to deliver a lesson the 67-year-old federal judge would never forget. Before diving into this explosive courtroom moment, make sure to hit the subscribe button and turn on notifications so you never miss the kind of moments where justice delivers unexpected consequences. Now, let's explore how a young black congresswoman from Texas dismantled one of the most self-assured judges in the country. To grasp how this clash became so consequential, it's important to know who these two figures are and what led them here. Judge Andrew H. Stones has served on the federal bench for over 2 decades. Appointed during a prior Republican administration, he's nicknamed the Gavel King among colleagues, known for running a strict courtroom where his word often ends the discussion. At 67, he's ruled over thousands of cases, thrown out hundreds of appeals, and cultivated a reputation for being dismissive of what he labels political theatrics or frivolous suits. Born into old Texas wealth, Stones has deep roots in the state's legal circles. He graduated from Harvard Law, clerked for a Supreme Court justice, and throughout his career rarely encountered a serious challenge to his authority. His courtroom decor reflects a bygone era, portraits of white, male legal giants reinforcing a traditional view of the law. Crockett, however, stands for everything that unsettles judges like Stones. At 33, she's a former civil rights attorney who rose from working-class St. Louis to become a congresswoman representing Dallas. She paid her own way through law school, built a legal practice defending low-income clients, and earned her seat in Congress by defeating entrenched political interests. Crockett is not your typical politician. She's a former public defender who knows courtrooms intimately and isn't afraid to call out injustice no matter who's wearing the robe. The case that brought them together seemed ordinary, a civil rights lawsuit over voter suppression in Texas. Typically, such cases get dismissed or quietly settled, but this one was different. It included hard evidence of widespread voter suppression that Crockett herself helped gather. The implications were enormous. This wasn't about one lawsuit. It was a test of whether federal courts would still uphold voting rights or allow judges like Stones to treat civil rights as political noise. For Crockett, this was personal and professional. For Stones, it was just another day. What he didn't know was that she had spent months preparing. She had studied his rulings, patterns, and weaknesses, and was ready to use it all. Tension had been building for weeks in Stone's courtroom, but the first hour of proceedings set the tone for what would become a landmark confrontation. It began with the subtle slights. Stones repeatedly mispronounced Crockett's name as Crochet, despite multiple corrections. He allowed opposing counsel to interrupt her without consequence, while cutting her off mid-sentence. He rolled his eyes as she cited recent legal precedents. "Your Honor," Crockett said during her opening statement, her voice steady, "the evidence will demonstrate a systematic effort to suppress votes, violating the constitutional rights of over 50,000 Texans." Judge Stones leaned back with a smirk. Congresswoman Crockett, he said, deliberately mispronouncing again. Those are serious claims. I hope you've brought more than political talking points. The first red flag appeared when he sustained every objection from the defense, no matter how weak. When Crockett showed evidence of polling places closing, in black communities, Stones questioned its relevance. When she presented data showing racial disparities, he called it speculative. But the moment things escalated came when Crockett attempted to introduce video footage. Your Honor, we have security camera recordings from 3 polling sites where eligible voters were turned away, she said, holding up a tablet. Objection, the defense barked. Prejudicial and inflammatory. Sustained, Stones ruled, barely glancing up. Move on, Congresswoman. Crockett's jaw clenched. Your Honor, this is direct evidence. I said move on, Stones snapped, his voice echoing with authority. Unless you've got more than shaky cell phone clips, we're done here. Even the defense looked uneasy with how dismissive he was. But Crockett didn't back down. With respect, Your Honor, this footage captures real-time constitutional violations. And then Judge Stones made his critical error. He laughed. Not a polite chuckle, a full, dismissive belly laugh. Congresswoman, he said through his laughter, I've been on this bench 20 years. I've seen every stunt. Maybe these videos work in Congress, but this is a court of law, not a poli-sci class. The room froze. Crockett stood motionless, hands on the table. When she looked up, something had changed. The professional mask dropped, replaced by controlled, righteous anger. Your Honor, she said firmly, I'd like to approach the bench. That won't be necessary, Stones said, waving her off. Let's move on to your next point. But Crockett didn't move. Instead, she reached into her briefcase and pulled out a thick folder. Before we proceed, she said, this court must address some procedural concerns. Stones's smirk faded. What concerns? He asked, voice tight. Crockett opened the folder. The sound of papers rustling echoed ominously. Well, Your Honor, we need to discuss your record in civil rights cases over the last 5 years. Murmurs swept the room. The court reporter froze. The gallery leaned in. Stones's face began to redden. Excuse him? Yes, Crockett replied calmly. Before today, I reviewed your complete judicial record. What I found was revealing. She let the word linger like a warning. You're out of order, Stones said sharply. Actually, Your Honor, Crockett replied, her first smile of the day breaking through. I don't believe I am. What followed would be studied in law schools for decades. Crockett stood tall, holding a folder that would unravel a judge's career. Since you mentioned your 2 decades of experience, she began, let's examine that record. Stone's face moved from confusion to visible panic. This is improper, he protested. What's improper, Crockett countered, is a federal judge showing a repeated pattern of bias in civil rights cases. She opened the folder. Let's start with Morrison v. Texas Secretary of State, 2023. You dismissed clear evidence of voter suppression while mocking the plaintiff's attorney. That case was dismissed on procedure, Stones objected. Was it? Crockett said, pulling out transcripts. You told counsel, and I quote, maybe stick to personal injury cases. The gallery gasped. Crockett continued. Next, Henderson v. Texas Board of Elections, 2022. You not only dismissed the case, you sanctioned the lawyers, claiming they were chasing media attention. That sanction was reversed on appeal. The court called your conduct inappropriate and potentially biased. Yet you never apologized. Chaos broke out in the room. Reporters scribbled. Defense lawyers whispered frantically. Shall I go on? Crockett asked. Because I've got 12 more. She laid out documents like cards in a courtroom poker game. Williams v. Texas, DPS, dismissed as political theater, reversed on appeal. Jackson v. Harris County. You told the lawyer to stop wasting the court's time. Reversed. Thompson. v. Texas Legislature. Dismissed with prejudice after you told the plaintiffs to find a new hobby. Reversed again, this time with a formal reprimand from the Judicial Conduct Board. With every case, Stones seemed to shrink. Then came the final blow. And finally, Davis versus Texas Attorney General 2021, Crockett said. You told the plaintiffs, and I quote, "These people need to stop complaining about every little rule." The courtroom exploded. But here's the key, Your Honor, she added. That case was reversed, and your conduct referred for investigation by the Judicial Conduct and Disability Committee. That investigation was inconclusive. Stones whispered. Yes, Crockett agreed, because federal judges are hard to investigate. But if new evidence emerges, like 12 more cases with similar misconduct, well, it might be reopened. She gestured to the stack of documents. New evidence, new pattern, new grounds. The silence was suffocating. Crockett paused, then spoke, with clear, unwavering authority. Your Honor, I move for this court to recuse itself from this case due to demonstrated bias. I further request that this matter be reassigned to a judge with no history of inappropriate conduct in civil rights matters. She paused. And respectfully, I suggest you consider whether continuing to preside over such cases is in the interest of justice. But perhaps the most lasting effect was on the federal judiciary itself. Within months, the Judicial Conference announced mandatory training on bias in civil rights cases. The American Bar Association revised its guidelines for reporting judicial misconduct. Law schools began using Crockett's courtroom approach as a case study in how to advocate effectively for judicial accountability. 6 months later, Judge Stones quietly announced his retirement, citing a desire to spend more time with his family. Few were surprised. His successor, confirmed with bipartisan Senate support, was a civil rights attorney known for fighting the very types of bias Stones had come to symbolize. The broader impact stretched well beyond one courtroom or one judge. Crockett's confrontation exposed something long discussed in legal circles but rarely proven so clearly. Systemic bias within the federal judiciary could be identified, documented, and directly challenged. Her success encouraged other attorneys to begin gathering evidence of bias in their own jurisdictions. Within a year, similar legal challenges appeared in courts nationwide. Legal scholars dubbed her approach the Crockett Protocol, which soon became a model for holding biased judges accountable. The political ripple effects were equally significant. Crockett's reputation soared within the Democratic Party. Her skillful use of the law to uncover systemic bias made her a leading voice in the judicial reform movement. Criticism from Republican figures noticeably declined after legal experts across the political spectrum praised her courtroom performance. More importantly, her success showed that entrenched systems protecting biased judges could be confronted and changed. It was proof that detailed research, legal strategy, and moral determination could overcome even the most resistant institutions. Yet Crockett remained focused on the broader mission. In interviews after her courtroom win, she repeatedly emphasized that this wasn't about one judge or one ruling. It was about ensuring that every American, regardless of background, receives fair treatment under the law. Speaking to CNN, she said, Judge Stones was just one example of a much deeper issue we need to address. She used her growing platform to advocate for wider reforms. Public reporting of judicial decisions broken down by demographic trends, mandatory bias training for all federal judges, and simpler procedures for filing judicial misconduct complaints. What happened in Judge Stones's courtroom that day became more than just a viral moment. It became a symbol of what's possible when the legal system is held accountable by individuals equipped with knowledge, preparation, and courage. For young lawyers, especially women and minorities, Crockett's win proved that skill and readiness could overcome systemic barriers. For civil rights advocates, it confirmed that, despite its flaws, the legal system could still serve justice. And for Judge Andrew H. Stones, it was a powerful reminder that in the United States, even federal judges are not above accountability. The case files Crockett presented in that courtroom are now part of the permanent record, a symbol of the strength found in careful preparation and the courage to challenge authority. They now rest in the National Archives, available to any researcher studying how systemic bias in the judiciary was finally confronted and dismantled. But perhaps the most important legacy was the message it sent to every biased official and every figure who believed their position made them untouchable. Someone is always observing, always taking notes, and someone like Jasmine Crockett may one day hold them accountable. The day a 33-year-old Congresswoman walked into federal court and dismantled a judge's career using nothing but legal research and conviction marked a defining moment in American legal history. It proved that justice, though delayed at times, is never truly out of reach when people are willing to fight for it. What are your thoughts on Jasmine Crockett's groundbreaking courtroom performance? Have you ever seen systemic bias challenged so powerfully? Let us know in the comments. And don't forget to subscribe and click the notification bell so you never miss moments where truth and justice prevail over institutional power. The next time someone tells you one person can't make a difference, remind them of the day Jasmine Crockett entered Judge Stones's courtroom and reshaped American jurisprudence forever.